This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about a man bites dog story where State Farm and various State Farm auto insurance company obtained an injunction against a doctor to stop fraudulent no-fault accident claims. In State Farm Mutual versus Herschel Kotkes et al., a July 13, 2023 decision of the United States District Court for the Eastern District of New York, plaintiffs, the various State Farm insurers, and Herschel Kotkes, alleging that Dr. Kotkes defrauded State Farm by submitting hundreds of fraudulent bills for no-fault insurance charges on behalf of insured patients who were involved in automobile accidents. State Farm alleged common law fraud and unjust enrichment, seeking damages for benefits paid under no-fault insurance policies to Kotkes. State Farm also sought a declaratory judgment establishing that, among other things, it is not obligated to pay unpaid pending claims submitted by Kotkes, and sought an injunction to stop him from bringing any further claims or proceeding with his claims that have not yet been paid. Under New York law, an automobile insurer must provide no-fault insurance benefits to the individuals they insure for necessary health care expenses resulting from automobile injuries for up to $50,000. No-fault insurers like State Farm may reimburse patients without requiring proof of negligence. An insured may assign their claim to their provider, who then bills the insurers directly. Defendants are Dr. Herschel Kotkes and his medical practice, Herschel Kotkes, MD, PC. Kotkes is a pain management specialist whose practice includes treating insureds who have been involved in automobile accidents. The insureds assign their policies to Kotkes, who bills State Farm for the treatment purportedly rendered. State Farm alleged that Kotkes, since at least 2017, has been systematically submitting fraudulent and misleading claims to State Farm. Kotkes almost always described patients' complaints in the same way as nonspecific neck and or low back pain, diagnosed 99% of patients with radiculopathy in either the lumbar or cervical region or both, along with intervertebral disc displacement in the corresponding region, but without specifying the particular location on the spine. The random sample of 86 patients also revealed that Kotkes provided the same prognosis for 98% of those he treated and recommended the same combination of treatment methods for nearly all patients. State Farm asserted 3 causes of action for common law fraud and unjust enrichment, under which it seeks damages for claims already paid to Kotkes, and for declaratory judgment, under which State Farm seeks a judgment declaring that Kotkes is not entitled to reimbursement for claims submitted to State Farm that have not been paid to date and are unpaid through the pendency of the litigation. Under New York law, to state a claim for fraud, a plaintiff must demonstrate 1. A material misrepresentation or omission of fact, 2. which the defendant knew to be false, 3. which the defendant made with the intent to defraud, 4. upon which the plaintiff reasonably relied, and 5. which caused injury to the plaintiff. State Farm points to Kotkes' own testimony from an examination under oath in a state court collection action, where he testified, for one, that he does not believe that certain procedures are medically valuable, but that he performs them as a matter of course. Kotkes also testified that it is his practice to perform a percutaneous discectomy and an IDET, 2 mutually exclusive procedures, at the same time and using the same needle. State Farm adequately alleged that Kotkes had motive to commit fraud to gain a financial benefit of hundreds of thousands of dollars in insurance payments by submitting claims to State Farm. State Farm also adequately alleged that Kotkes had opportunity to commit fraud, specifically that Kotkes could submit claims to State Farm that allegedly misrepresented the necessity of certain treatments or inflated the bills for certain treatments. State Farm adequately pled that it reasonably relied on Kotkes' misrepresentation and was injured as a result, and State Farm has alleged the elements of common law fraud. State Farm has adequately and plausibly alleged that Kotkes made fraudulent statements in submitting the claims at issue. State Farm alleged fraudulent knowledge and intent by showing Kotkes' motive and opportunity to submit fraudulent claims to take advantage of New York's no-fault insurance scheme. Common law fraud is sufficiently pled, and Kotkes' motion to dismiss the common law fraud count was denied. State Farm has established, according to the district court, a substantial controversy between the parties whether Kotkes is entitled to payment on pending claims presented to State Farm or whether, due to Kotkes' alleged fraudulent schemes, State Farm is under no obligation to pay. Therefore, State Farm's motion was made for a preliminary injunction, and it alleged that as of March 23, Kotkes initiated 103 arbitrations and 95 state court lawsuits seeking payment on claims that State Farm has refused to pay, uncovering the alleged fraudulent scheme and initiating the instant federal lawsuit. As of March 24, 2023, approximately $1,188,841.32, which is far from approximate, in unpaid claims was at issue in pending state court litigation and arbitrations, and $1,787,989.98 of Kotkes' billed unpaid amount was not yet the subject of pending collection, litigation, or arbitration, thereby having pending more than $3 million in litigation and expense payments. New York courts routinely collection actions pending declaratory judgment proceedings, and accordingly, State Farm's request to the court that it stay pending no-fault collection actions in state court was granted. For the reasons stated, State Farm's motion for preliminary injunction was granted in full. Specifically, the court granted State Farm's request to stay pending state civil court proceedings and no-fault arbitrations against State Farm by Kotkes, and enjoins Kotkes from filing any new collection actions against State Farm seeking no-fault benefits, whether in state court or in arbitration proceedings pending resolution of the declaratory relief action. Absent further order of the court, State Farm's obligation to post security was waived. In my opinion, because insurance fraud, especially with regard to individual small amounts, the only means of deterring insurance fraud relating to no-fault insurance claims assigned to less than scrupulous healthcare providers is to sue the providers for fraud and seek an injunction stopping them. State Farm should be commended for its proactive work against Dr. Kotkes and was properly provided an injunction stopping further claims while litigating the declaratory relief and fraud suit. The evidence appears overwhelming, and I look forward to reading about the results at the trial. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and receive notice of every blog posting, usually 5 or 6 a week. And it is free, and you can also subscribe to the free videos at youtube.com or at rumble.com. And if you do, I'd appreciate it if you click on the like button or the thumbs up button on rumble.com. And if you found this video useful, please tell your friends and colleagues so that they can also subscribe. And if you wish further detail and further information on insurance law, insurance claims, and insurance fraud, please consider subscribing to my Substack publications or to my locals community. Thank you for your attention.